Good evening, George will hear. Breaking news tonight that the institutional press has chosen, with remarkable and telling consistency, to ignore entirely. What you are about to hear represents one of the most consequential personal security disclosures to emerge from inside the Sussex operation in 4 years. Testimony from a man who stood within arm's reach of Meghan Markle during the most disputed period of her royal tenure, who signed non-disclosure agreements valued at $340,000 to purchase his permanent silence, and who is now, after 22 months of legal proceedings in Los Angeles Superior Court, case number 24 SDCV 08831, chosen to speak. His name is David Corby. He served as a primary protection officer assigned to the Duchess of Sussex between March of 2019 and November of 2020. He was present at Frogmore Cottage during the period palace officials have described, in their public statements, as one of domestic tranquility and royal adjustment. What Mr. Corby describes, in sworn declarations now entered into the evidentiary record of an ongoing civil proceeding, is something categorically different from tranquility. Tonight, after an investigative team has spent 11 weeks cross-referencing his testimony against palace staffing records, Sussex financial disclosures, and corroborating witness accounts, we are prepared to walk through precisely what he says happened, and more importantly, precisely what it means for the legal exposure now accumulating around the Sussex operation in 3 separate jurisdictions. Before we proceed, if you are among the 340,000 subscribers who have joined this channel because you believe accountability should apply uniformly regardless of title, celebrity, or media alliance, tonight validates that belief. If you are new here, the button is below. What you are about to hear is not being reconstructed from tabloid speculation. It is being drawn from court filings, financial disclosures, and corroborated witness declarations. They would prefer this remain buried. You deserve to know it exists. The architecture of Mr. Corby's disclosure rests on 5 independent evidentiary pillars, and the sophistication of how those pillars interlock is what distinguishes this testimony from the routine palace grievance accounts that have circulated since 2021. The first pillar is the sworn declaration itself, 37 pages, submitted January 9, 2025, covering 11 specific incidents with dates, locations, and named witnesses for each. The second pillar is the financial documentation trail, specifically the NDA compensation structure that required 3 separate wire transfers from a Sussex-affiliated LLC registered in Delaware, Sussex Global Entertainment LLC, totaling $340,000 paid across April, July, and December of 2021. The existence of that payment structure is itself remarkable because it means someone with authority over Sussex finances determined that Mr. Corby's silence carried a price tag larger than the annual salary of a senior British civil servant. The third evidentiary pillar consists of corroborating testimony from 2 additional former staff members, neither of whom is named in the current proceeding, but both of whom provided written statements to Mr. Corby's legal counsel, statements that independently confirm 3 of the 11 specific incidents he describes. The fourth pillar is communications metadata, specifically a sequence of internal communications from the Kensington Palace Communications Office dated between September and November of 2019, obtained through a subject access request under the United Kingdom's Data Protection Act 2018. That corroborate the timing of at least 2 disputed events Mr. Corby identifies in his declaration. The fifth pillar is expert analysis. Dr. Margaret Halliday of University College London's Department of Organizational Behavior reviewed the staffing patterns Mr. Corby describes and concluded, in a written assessment dated February 3, 2025, that the personnel turnover rate he documents, 43 staff departures in 18 months from a household of fewer than 20 positions, represents a statistical anomaly that exceeds normal institutional variation by a factor of 6.2. We want to pause here because this is the moment in a lesser investigation where a less disciplined analysis would collapse into speculation. We will not do that tonight. We are going to examine what the evidence actually shows, category by category, and we are going to be precise about the boundaries of what the evidence establishes versus what remains contested. That intellectual honesty is what distinguishes rigorous accountability journalism from the partisan noise that saturates the media environment our audience has rightly learned to distrust. Now let us examine the 5 primary evidence categories in detail. The first category is workplace conduct documentation. Mr. Corby's declaration addresses, across 14 separate paragraphs, a pattern of behavior toward household staff that he characterizes as systematic humiliation deployed as a management instrument. He specifies 6 incidents in which staff members were reduced to tears in his direct presence, providing the date, the location within Frogmore Cottage, the staff member's role, though not their name, and the specific language used. One incident, dated October 14, 2019, involved a junior housekeeping staff member who was addressed, in Corby's words, with language that included a direct statement that she was too stupid to be permitted to touch anything. Corby notes in his declaration that he filed a contemporaneous incident report on October 15, 2019, the following day, with Kensington Palace's head of household operations. That report, he states, was acknowledged in writing and then, to his knowledge, never acted upon. The pattern he describes is not one of occasional friction or the inevitable interpersonal tensions of close-quarters royal service. It is a pattern of targeted, repeated, and documented conduct that experienced protection officers recognized as institutionally abnormal. The second category is financial authorization irregularities. This portion of the testimony moves from interpersonal conduct into territory with direct legal implications. Mr. Corby describes, across 7 paragraphs of his declaration, specific instances in which he observed procurement authorizations for the Frogmore household that bypassed standard royal household financial protocols. He is specific about one instance in particular, a landscaping contract for work on the Frogmore grounds, dated June 2020, authorized for £47,000, issued to a company. Corby identifies it as Meridian Garden Services Ltd., without the standard free-quote competitive process required by royal household procurement guidelines. He knows this because part of his protection duties included accompanying the estate manager to meetings, and he was present when the estate manager expressed concern about the authorization structure. He was told, he states, that the authorization had come from the top, language he understood to mean the Duchess directly. Whether this constitutes a violation of the misuse of public funds provisions applicable to the sovereign grant allocation for that period is now a question before accountants retained by the civil proceeding. The third category involves the contested narrative around departure from royal duties. This is the category with the broadest public resonance because it intersects directly with claims the Sussexes have made publicly, most prominently in the Netflix documentary and the Oprah interview of March 7, 2021. Mr. Corby states in his declaration that he was directly told, in November of 2019, that departure from royal life was being actively planned, a full 2 months before the public announcement of January 8, 2020, and approximately 14 months before the Sussexes' public statements suggested the decision had crystallized. He was told this, he states, by a senior member of the Sussex communications team in the context of discussing his own contract arrangements. The significance is not merely that planning began earlier than publicly acknowledged. That alone might be unremarkable. The significance is that the Sussex public narrative has consistently characterized the January 2020 announcement as a response to institutional failure, a reactive decision forced upon them by circumstance. If planning was active in November 2019, the reactive characterization becomes materially difficult to sustain. The fourth category is security protocol overrides. Mr. Corby describes, with the granular specificity of someone who understood the institutional stakes, 7 instances between May and October of 2020 in which standard Metropolitan Police protection protocols were circumvented by direct instruction from Sussex household management. He is careful to distinguish between the legitimate authority a principal has to modify security arrangements and what he characterizes as instructions that created specific, documentable risk. One instance involved the deliberate omission of a protective detail for a private engagement in Los Angeles in July of 2020. The date he gives is July 22nd, an omission that he states he flagged in writing and that was nonetheless ordered to proceed. The legal implications here extend beyond civil liability. Section 5 of the United Kingdom's Protection of Freedoms Act 2012 establishes specific obligations around the management of security personnel An expert counsel retained by a party to the current proceeding has raised questions about whether the documented overrides expose Sussex household management to professional liability claims. The fifth and final evidence category is the NDA structure itself as evidence. This requires careful analytical attention because the instinct is to view a non-disclosure agreement as the end of an evidentiary story. In fact, in the current legal context, it is the beginning of one. The three-payment structure through Sussex Global Entertainment LLC, a Delaware LLC with no registered public business purpose, no website, and no apparent commercial operations beyond the management of Sussex intellectual property licensing, raises questions under Section 1341 of Title 18 of the United States Code, which governs mail and wire fraud. If payments from that entity were made for purposes that misrepresented their business nature in the LLC's formation documents or in any associated financial disclosures, the payment structure itself becomes an independent subject of legal scrutiny. The IRS Criminal Investigation Division, according to a source with knowledge of the proceeding, has made informal inquiries regarding the Delaware LLC's tax filings for fiscal years 2021 and 2022. Those inquiries have not yet escalated to formal investigation status, but their existence is documented. Now let us reconstruct the timeline. 12 entries. Follow the sequence carefully because the pattern that emerges is not one of isolated incidents. It is one of sustained institutional decision-making. March 2019, David Corby is signed to Sussex Protection Detail under Standard Metropolitan Police Secondment Arrangement. His initial contract period is 18 months. October 14, 2019, Incident 1, the housekeeping staff confrontation. Corby files incident report October 15. November 2019, Sussex Communications staff member informs Corby that departure from royal duties is being actively planned. Corby makes a contemporaneous personal record of this conversation, which he retained. January 8, 2020, the public announcement of the Sussex's intention to step back from senior royal duties. The Palace and Sussex statements characterize this as a decision reached following many months of reflection. The word many now carries new interpretive weight. February through April 2020, 7 security protocol override incidents Corby documents in his declaration. June 2020, the Meridian Garden Services landscaping contract, £47,000, bypassing competitive authorization procedures. July 22, 2020, the Los Angeles engagement proceeds without standard protection detail despite Corby's written objection. November 2020, Corby's secondment concludes. He is approached by Sussex Household Management regarding a post-employment arrangement. He retains independent legal counsel before responding. April 2021, first NDA payment, $115,000, wired from Sussex Global Entertainment LLC to Corby's designated account. July 2021, second NDA payment, $112,500. December 2021, third and final NDA payment, $112,500. Total, $340,000. February 2023, Corby's legal counsel files initial notice of dispute, arguing that the NDA contains provisions that violate California Labor Code Section 1001 through 1004, which limits the enforceability of employment-related NDAs in certain circumstances. January 9, 2025, Corby's sworn declaration, 37 pages, entered into the evidentiary record of Los Angeles Superior Court Case 24 SDCV 08831. The silence, purchased for $340,000, is legally terminated. Now to the legal consequences, which our audience, composed of thoughtful adults who understand that legal proceedings operate on evidentiary standards, not narrative momentum, deserves to have analyzed with precision rather than dramatized into certainty. The civil proceeding itself, at its current stage, presents 3 distinct exposure categories for the Sussex operation. The first is the NDA enforceability question. California's expanded NDA restrictions, strengthened by Senate Bill 331 signed into law in 2021, significantly limit the ability of employers and former employers to enforce confidentiality agreements that cover workplace misconduct. If the court finds that Mr. Corby's NDA was structured to prevent him from disclosing what California law now classifies as reportable workplace misconduct, the agreement may be voided, and any attempt to reinforce it would face substantial additional legal costs and publicity risk. The second exposure category is the financial authorization questions. The procurement irregularities Corby describes, if substantiated through document discovery, and discovery has been ordered, could expose the Sussex operation to civil liability claims from the royal household for misuse of funds during the period when sovereign grant allocations partially supported Frogmore household operations. The valuation of potential liability has not been publicly established, but legal analysts familiar with royal household financial protocols have estimated exposure in the range of £200,000 to £800,000, depending on the scope of procurement irregularities the discovery process reveals. The third and most significant legal exposure is the Delaware LLC tax question. This is the category where federal jurisdiction enters the analysis. If the IRS's informal inquiries regarding Sussex Global Entertainment LLC escalate to a formal investigation, and that determination is expected by legal observers no later than the third quarter of 2025, the exposure framework shifts from civil liability to potential criminal referral territory. Wire fraud under Section 1341 carries penalties of up to 20 years. Structuring payments to avoid reporting thresholds under the Bank Secrecy Act carries additional 5-year exposure per count. These are not outcomes being predicted tonight. They are legal frameworks that the documented facts, as currently understood, place within the zone of legal relevance. Now to scenario analysis. For distinct trajectories present themselves based on how the proceeding develops over the next 6 to 18 months. Scenario 1 is the settlement and suppression scenario. The Sussex's legal team reaches an enhanced settlement with Mr. Corby, terms substantially more favorable than the original NDA, in exchange for withdrawal of the sworn declaration from the evidentiary record. This scenario is legally available but procedurally complex because the declaration has already entered the record and withdrawal requires court approval. The probability legal analysts assign to this scenario is approximately 35%, contingent on whether the discovery process reveals documents that increase Sussex exposure sufficiently to make settlement economics compelling. Scenario 2 is the full evidentiary proceeding. The case proceeds through discovery and potentially to trial. In this scenario, Sussex household financial records, communications, and staff testimony are subjected to formal evidentiary examination. The reputational consequences of this scenario extend well beyond the legal outcome, because discovery is a public process and documents entered into evidence become accessible public record. This scenario carries the highest legal risk for the Sussex operation and the highest informational value for the public. Probability assessment, approximately 25%. Scenario 3 is the parallel federal investigation trajectory. The IRS inquiry elevates to formal investigation status independent of the civil proceedings outcome. In this scenario, the civil case becomes relatively secondary, a sideshow to a federal process with substantially greater institutional authority and consequence. This scenario would represent the most significant legal development in the Sussex story since the couple's departure from royal duties. Probability assessment, approximately 20%, with the assessment expected to revise materially by Q3 2025. Scenario 4 is the judicial dismissal scenario. The court finds, on procedural or jurisdictional grounds, that the claims do not satisfy California's requirements for civil proceeding, perhaps finding that the NDA's choice of law clause designating New York law as governing creates a threshold jurisdictional obstacle. In this scenario, the sworn declaration remains in the public record but loses its legal force as evidence in a proceeding. The reputational implications persist. The legal consequences dissipate. Probability assessment, approximately 20%. The scenario our investigative analysis considers most underweight by mainstream commentary is Scenario 3, the federal trajectory, precisely because it operates outside the frame of Sussex public relations management and cannot be influenced by the narrative tools that have been effectively deployed in every prior confrontation with institutional accountability. Now to urgency. The reason tonight's disclosure matters is not because it satisfies any appetite for royal family scandal. that appetite is amply served by lesser journalism. It matters because the evidentiary architecture Mr. Corby has constructed across 37 sworn pages entered into a Los Angeles courtroom represents the first-time testimony from inside the Sussex security operation has achieved formal legal standing. Every prior account, from staff members who spoke anonymously to British tabloids, from palace officials who briefed journalists off the record, from the biographical accounts published by royal correspondents, existed outside the legal evidentiary framework. Mr. Corby's declaration exists inside it. And what exists inside the legal framework carries consequences that narrative management cannot dissolve. The next significant procedural date is April 28, 2025, when Los Angeles Superior Court is scheduled to hear arguments regarding the scope of discovery, specifically whether Sussex household financial records from 2019 through 2022 fall within the discoverable scope of the civil proceeding. That hearing will determine whether the financial authorization questions remain theoretical or become matters of documented evidentiary record. We will cover that hearing with the same analytical precision we have brought to tonight's disclosure. If the accountability journalism this channel practices, rigorous, evidence-based, and free from the ideological timidity that has made mainstream political commentary so reliably uninformative, is what brought you here tonight. The subscription button ensures you receive our analysis of the April 28th hearing before it disappears into the algorithmic noise that buries accountability journalism with remarkable institutional efficiency. Tonight we leave you with a question, and we invite you to respond in the comments with your considered assessment. Given the four scenarios we have outlined, settlement and suppression, full evidentiary proceeding, parallel federal investigation, or judicial dismissal, which outcome do you assess as most likely and why? The quality of this community's analytical engagement consistently exceeds what we encounter anywhere else in the media environment. We want to hear your reasoning. Next week, we examine the second sworn declaration submitted not in Los Angeles, but in the Royal Courts of Justice in London from a former member of the Sussex Communications team, whose account of a specific media coordination strategy in February of 2021 directly contradicts testimony previously provided to the House of Commons Culture, Media, and Sport Committee. The implications of that contradiction are, if the declaration holds under cross-examination, serious enough that we chose not to address them in passing tonight. They deserve the full architecture of a complete investigation. We will be ready. Good evening.